I will read a statement on behalf of the President of the Law Society of Kenya. My name is Manyora, Vice President, Law Society of Kenya. Together with me are the Council members of the Law Society of Kenya. A statement on the withdrawal of security detail of Honorable Mr. Justice Lawrence Mugambi. The Law Society of Kenya, LSK, stands at the forefront of upholding the principles of justice, accountability, and the rule of law within our nation. With a deep commitment to safeguarding the rights and welfare of all Kenyans, it is our solemn duty to address the disturbing developments surrounding Honorable Mr. Justice Lawrence Mugambi, a sitting judge of the High Court whose security detail was recently withdrawn following his issuance of a habeas corpus order in the case of the Law Society of Kenya and 3 others versus the Inspector General of Police and 4 others, this being petition number E436 of 2024, which culminated in contempt of court proceedings, where the acting Inspector General was subsequently found in contempt and sentenced on the 13th of September 2024. This action by the National Police Service constitutes an egregious violation of the rule of law and the principle of judicial independence as enshrined in our Constitution. The LSK strongly condemns this retaliatory measure, which undermines not only the authority of the judiciary but also the constitutional protection granted on all Kenyans. Article 160 of the Constitution of Kenya guarantees judicial independence, stating that in the exercise of judicial authority, the judiciary shall be subject only to the Constitution and the law, and not be subject to the control or direction of any person or authority. The withdrawal of the security for a judge, especially in response to their lawful execution of judicial duties, is a direct violation of this constitutional provision. Judicial officers must be free to make decisions based on the law without fear of coercion, intimidation, or interference. Any act that seeks to influence judicial outcomes through intimidation poses a grave threat to the administration of justice. The National Police Service, as a key state actor, has a constitutional obligation under Article 244 to comply with the law and the decisions of the court. The continued defiance of the habeas corpus order with the law and the decision of the courts, the continued defiance of the habeas corpus order by failing to produce the individuals named in the case, and the contempt of court proceedings that followed reflect a dangerous trend of law enforcement disregarding judicial orders. This is not only unlawful but also sets a dangerous precedent for impunity, where state institutions operate without accountability. It is important to stress that any party dissatisfied with court ruling should pursue redress through the appellate jurisdiction rather than resorting to punitive or retaliatory actions against the judiciary. Article 165 of the Constitution outlines the procedure for appealing to higher courts, and any grievances within a judicial decision must be addressed within this framework. The intimidation of a judge has far-reaching implications beyond the individuals involved. It poses a significant risk to the administration of justice, as it suggests that judicial decisions can be influenced by external pressures rather than by law. The erosion of the judicial independence undermines the foundation of our constitutional democracy, where rights are safeguarded by an impartial and independent judiciary. The Law Society calls upon the National Police Service and all relevant state actors to immediately reinstate the security detail of Honorable Mr. Justice Lawrence Mugambi. We also urge them to comply with the orders of court, including the habeas corpus directive, as failure to do so is not only contemptuous but also indicative of a disregard for constitutional principles. Further, we call on the executive and all arms of government to respect the principle of separation of powers and to uphold the rule of law. Judicial independence is not merely a privilege for the judiciary, but a cornerstone of justice for all Kenyans. The Law Society of Kenya assures all Kenyans that it will remain committed to defending judicial independence, the rule of law, and constitutionalism. We will work to advocate for the protection of human rights and the integrity of our democratic institutions. That is all. Thank you.
Leading to, since last week we have been in this court, and the week before that on the question of contempt of court of the Inspector General of Police. Today we were informed that the security of Honorable Lawrence Mugambi was withdrawn, and this is attributed to the decision of the court last week finding and sentencing the Inspector General of Police to 6 months in prison for violation of 7 court orders. We believe as a law society that this is an attempt against the independence of the judiciary, and as a law society we will continue to fight impunity to ensure that the rule of law is followed. We are supposed to be before this court on this week on Thursday, when the 7 days expire that was given to the Inspector General to redeem himself. But we are surprised that he did not grab that chance, or he doesn't intend to grab that chance. In any case, he has proceeded to withdraw the security of a judge of a superior court. This has never happened before. It's the first time this is happening to a judge, at least under this government. And it's very important, and we want to remind officers who are actually serving us in different government institutions that compliance with court orders is not a favor you're doing, but it's the oath of office that you took to ensure that you respect the law that puts you in that office. And so we are putting the Inspector General on the spot, and we are hoping that as the Vice President has said, the security of Honorable Justice Mugambi will be reinstated immediately, at the same time that he will comply with court orders to redeem himself. Otherwise, of course, the court orders remain as they were. The Cabinet Secretary for Ministry of Interior was directed that in the event he does not present himself to a prison facility, then he has a duty to deliver the Inspector General to that facility, or whichever facility that that they will choose for that matter, because those are court orders. They are not optional. They are supposed to be complied with. As a law society, we intend to issue further, to file further proceedings against the said directive and against the said decision to purport to withdraw the security of a judge, because it amounts to gross misconduct and abuse of office. Thank you very much.
William?
My name is Manuel Jose. I'm a council member.